Hello, and welcome to today's program titled Critical Return to Work Issues for Employers. This time, all participants are in a listen-only mode. For those of you who are logged in to the web presentation, you are encouraged to submit questions throughout the conference by typing them into the text box on your screen. For those of you interested in obtaining CLE credit for this webinar, an attendance verification code will be read during the presentation, and it will be required on the CLE attendance affirmation form. Please write this code down. It will not be reread, and it is required for the CLE credit. Copies of the webinar, recording, and materials will be distributed to attendees in the days following the webinar. At this time, I'd like to turn the conference over to Camille Olson. Go ahead, ma'am.
Thank you, and hello, everyone. My name is Camille Olson, and I'd like to welcome you to today's webcast. I'm in Chicago today. I am joined by my Seyfarth colleagues in Atlanta and in California, who will also be presenting. We are a subset of over 100 Seyfarth attorneys across the firm who make up a cross-disciplinary COVID-19 task force that includes attorneys from our employee benefits, tax, corporate, health and safety, traditional labor, workforce restructuring, and litigation practice groups. You are one of over 3,500 registered attendees today. As a result, we encourage you to use the chat feature to provide us with both questions as well as feedback on issues you'd like to see us cover in future webcasts. Because time is limited to 60 minutes today, we do not anticipate being able to answer your questions directly during today's webcast. Today's webcast is the first in a series of webcasts that will be offered over the coming weeks on a variety of topics and legal considerations as you prepare to return to work. Our goal today is to raise awareness of the myriad of issues and considerations relevant to returning to work, which is also being called by some as looking forward to work. Your input will be invaluable as we are providing you with that analysis and interpretations that you will need on your most pressing issues. With that, we're going to move to what is, I'm sure, much anticipated, which is our legal disclaimer. It's pretty common in these presentations, and it notes that our presentation was prepared for informational purposes and that information should not be viewed as legal advice, but just general information, and that you are urged to consult with an attorney regarding any specific situation that you have. So let's take a look at the agenda today. It includes 5 topics. Our slide deck will be made available immediately following today's program to assist in your planning. You will note as we go through today's deck that we've included more text than usual on each slide, and that our presentation by design will not be covering each bullet. We've designed the webcast in this way to provide you both the slide's key information while also providing our analysis of the relevant legal considerations by topic. Let's get started. I'd like to first begin by introducing our presenters. Elizabeth Levy will discuss issues to consider before employees return following my initial presentation on your return to work framework. Next, Christina Medin will discuss logistics and communication considerations. Anne-Marie Zalatil will then review relevant protocols and their subparts. And Liz Watson will close out our webcast with additional insights into how to stay informed, be prepared, and be flexible, as well as provide you with additional Seyfarth resources on returning to work. Since we are in uncharted territory, we wanted to begin by setting the stage for your own return to work plans with the relevant frameworks. First, the COVID-19 limited global experience that we've seen. Second, federal, state, and local considerations and requirements. And finally, a quick look at industry differences. First, the limited global experience that we've seen. some companies in some areas of the world have gone back or are about to go back to work. The experiences differ greatly by country, region, or province, as well as industry, and the applicable legal standards and cultural norms that shape the differing approaches to the return to work actions taken by companies in various countries. There are a few blueprints that most are following. Return to work is not an event or occurrence, it's a process. Just as various companies saw rolling closures in mid-March of their operations, most companies are engaging in rolling openings or ramp-up. It's not an on-off switch, but more of a dial that may turn up and down depending primarily on evolving safety and health considerations. It's a decision not to be rushed for any company. Employee impacts abroad involve reorganizing employees' daily lives, including before coming to work, transportation to and from work, and travel generally, entering work, work schedules, work itself, including the physical plant or office space, and lunch breaks as examples. Companies have described significant changes that directly affect their global workforce. For example, Volkswagen issued new manuals with a list of 100 workplace changes, all designed to minimize the risk of coronavirus infections. Here on this slide, you see examples of some of those changes and the pace of opening in China, Germany, and Australia. The federal government has issued guidelines entitled Opening Up America Again. Those were issued on April 16, 2020, and you can see the website that's cited here for the plan. The guidance provides states with information on safe and sustainable reopening. Its focus is on empirical data and the gathering of that data on issues such as the presence of flu-like symptoms, confirmed cases, and available testing programs for the virus as well as antibodies and related healthcare readiness. It encourages governors in the various states to work together on a regional basis as appropriate. In the middle of the slide, you can see a couple of pending federal activities in this area of return to work. One is the April 15th letter from a majority of senators to Senators McConnell and Schumer to ensure that any new COVID-19 legislation includes a mandate that OSHA issues an emergency temporary standard for all essential workers, requiring employers to develop and implement a comprehensive plan to protect their workers that would include proper training and protection of workers, including with personal protective equipment, and access to various sanitary opportunities, both with respect to hand sanitizers as well as washing hands. Similarly, AFL-CIO President Richard Trumka has called on lawmakers to enact emergency standards to limit virus exposure and protect workers from retaliation if they don't feel safe returning to work in something that's been called the Working People's Plan. It includes job protection for workers who refuse to work due to virus fears, massive increases in the availability of protective equipment and virus testing, and a federal infection tracking system. These issues raise both safety and collective action rights under OSHA and the National Labor Relations Act for both unionized and non-unionized workers. There is also an act that was introduced in the House called the COVID-19 Early Worker Protection Act. It's sponsored by House Committee Education and Labor Chair Bobby Scott, as well as Congresswomen Alma Adams and Donna Shalala. It's safe to say that with respect to all these issues, whether or not one of these bills passes, that there is enormous pressure and focus on including some type of emergency equipment standard or emergency temporary standard with respect to safe workplaces for, at a minimum, essential workers, but also is being talked about with respect to all workers, as well as potentially additional labor priorities such as hazard pay, which would look something like premium pay at a rate of more than 100% of the employee's base salary. Numbers of 150% have been discussed, as well as opportunities and access to various PPEs. Most importantly, what I'd like to note is what employers must be guided by today, which is the fact that all of the applicable federal, state, and local laws relating to maintaining a safe work environment, employee privacy rights, non-discrimination and non-retaliation obligations based on protected statuses or for engaging in protected activities and others continue to apply to your back-to-work protocols and initiatives. These include the ADA, Title VII, other non-discrimination laws, OSHA, HIPAA, the National Labor Relations Act, wage and hour laws, as well as various state and local laws. Just today, for example, the EEOC issued a new technical assistance publication with respect to the Americans with Disabilities Act and other EEO laws. One other thing that isn't noted here, but is very important for all employers to be focused on, is the guidance that's being issued and updated almost daily by the Center for Disease Control, which describes in some detail, in particular with respect to return to work issues, which staff members are ready to return, when, and under what circumstances. As I noted on the prior slide, the federal guidance that was issued encouraged state alliances. We've probably all seen that 3 alliances have developed, one on the East Coast, one in the Midwest, and one on the West Coast, with the 3 goals that are set forth here. These governors in these various alliances have described rapid testing capacity as the absolute bridge to bringing people back to work. The goals of the alliances that are described focus on developing effective and abundant testing, tracking and isolation practices for the virus, and resources for healthcare systems caring for those who are sick. It is unlikely that these alliances will provide regional back-to-work orders, though the governors in the states are sharing best practices and information regarding current health information of their constituents. I've included a number of states that have announced reopen plans here. This is not a full list. For example, you might be thinking that Colorado as well has some very specific plans. It's noted here, but not all those plans are set forth. What does appear to be common among the state plans is the following. Social distancing continues, large gatherings are prohibited, some require workstations to be separated, and where appropriate, certain protective equipment or face coverings be worn. Another common practice is that it's not business as usual. Some require customers to be limited to a certain number per square feet, for example, in South Carolina, or in Texas, for example, where customers are not supposed to be entering retail premises when they are open. And then finally, and I think this is very important for us all to remember, very few of these opening orders have all businesses reopening at once. They are really phased approaches, as you can see from this very slide. I also just want to mention that there are industry as well as your own company-specific considerations, and that those will sometimes be paramount. Considerations that relate to employee wellness, facilities readiness, workforce return to work readiness, and your return to work plans will very likely vary greatly by industry. Consumer-facing companies are factoring in consumer expectations as they return to the places of business and steps that need to be taken to protect both customers and employees who come in contact with them. Industrial, manufacturing, and construction companies where work from home is less viable and more significant workplace changes may be necessary. Office-based companies where considerations with respect to clients, vendors, and off-site meetings and locations of business are often of primary relevancy, as well as employee expectations of a potential continued heavy reliance on telework. And then finally, high consumer density companies where barriers to regulating consumer density may require additional on-site resources. With this framework in mind, I will turn this over to Elizabeth Levy, who will discuss considerations before employees return. Elizabeth?
Thank you, Camille. So there are a number of issues for employers to consider before any employees walk back in the door. In broad strokes, you'll want to make sure that you have an understanding of the applicable laws. You'll want to make sure you have the right team in place to make changes, make decisions. There will be concerns regarding selecting which employees to return and how, remote work concerns, and concerns regarding individual employees and whether they're safe to return. So on that list, the first very important item is determining which federal, state, and local laws and orders apply. As Camille mentioned, these change rapidly, particularly on a local level. You may have an order that is issued and then guidance issued a few days later. FAQs may be issued and then updated. So it's extremely important to understand what is going to impact your business and to make sure that you have the most up-to-date information in terms of the relevant orders or guidance. Shelter-in-place orders are obviously extremely important. Sometimes they can include industry-specific requirements. They, as they are lifted, they, the requirements per industry may change. And again, it's just important to make sure that any local, city, county orders are adhered to along with statewide or other orders. OSHA is also a very large concern. You want to make sure that you avoid complaints, are able to deal with complaints if they arise. Make sure that you have the right health and safety protocols. Again, this is something that may vary by location. And going through the framework of federal, state, and local orders, there are a number of issues to consider in terms of paid sick leave, unpaid leave, other relevant laws that may already be in place. I'm sure many of you are familiar with the Families First Coronavirus Response Act, which will apply if there are fewer than 500 employees. A number of states and cities have taken steps to effectively extend the type of leave that would be federally available to employees that would not otherwise be entitled to obtain such leave. So it's critical that you just make sure that you're complying with any posting requirements, leave requirements in your specific jurisdiction. Another item to be mindful of is any potential traditional labor bargaining issues that may exist or may be on the horizon. As employees return to work, it's important to be mindful that health and safety issues can be a catalyst for bargaining. And again, local orders may impact what you can and can't bargain for or how certain things can be bargained for. And again, there will be and are industry-specific requirements. So, for example, healthcare is an obvious issue, but some particular orders call out assisted living facilities or nursing homes or grocery workers. There are a number of specific things, and these state and local orders can impact everything from, whether employees are required to have face coverings, again, to the paid sick leave. So there are just a number of things that will fall under the right umbrella once you determine which set of laws you need to work within. And if we move to the next slide, determining an organizational approach is equally important to make sure that you have the right people involved. Typically, you're going to have human resources, IT. You'll want to make sure that you're working with building management, particularly if you've had a facility closed for some period of time, maybe possibly a deep cleaning, et cetera, depending on the type of facility you're working within. You'll want to make sure that you have office managers and management assembled in the right kind of team to make the right kind of decisions. You may want to consider training some of these particular people on the issues that they may face as employers are coming back to the workplace. And I think that this goes a bit to some of the issues that Camille discussed, but in terms of whether you want to open your business to the extent that you're able to do so, if you'd like to consider a more staggered approach or open specific critical aspects of your business first, those are issues that you'll want to determine and have hammered out. ahead of time. And I know that an issue that a lot of people have questions and concerns about relates to the timing of bringing back certain employees and taking advantage of certain credits that may be available. And as Camille mentioned, we don't have time, just given the volume of all of these issues, we simply just don't have time to delve into that area today. Our tax and corporate folks are phenomenal and are able to answer specific questions in terms of credits that may be available related to timing, but the timing of bringing back certain employees is an issue that you'll want to make sure you've hammered down. And if we can go to the next slide, I'd like to discuss some issues that may arise in determining which employees will return to work, how those employees will come back, and again, when they'll come back is important. So the process of determining which employees will come back is, I think, going to be a difficult issue for a number of employers in terms of figuring out, for example, if you've furloughed a number of people, are they all coming back? If they're not all coming back at once, who is coming back? What positions are coming back? Are you looking at seniority? Are you looking at performance? There are a number of ways that process can unfold, and employers will want to make sure that they have a solid plan in place and that they're safeguarding themselves to the greatest extent possible against potential issues down the line if an employee, feels that maybe they should have come back at an earlier point. And another thing, just looping back to the importance of keeping track of local and state orders, some jurisdictions have actually considered enacting rules that would impact how employees are brought back. So it's just critical to make sure that you understand what is going to apply to your specific jurisdiction. Other issues to keep in mind, you may have employees that have already been on leave prior to the pandemic. You'll want to make sure that they're handled appropriately. You may have employees that are considered high risk that may have fears about coming back. If an employee is fearful of returning to work for a number of reasons, that may cause whistleblower concerns, that may cause ADA concerns. That is typically going to be a fairly individualized issue, but at the same time, having a policy and a protocol in place to properly handle those issues will help down the line. And another thing to keep in mind is that a number of employees may simply have logistical issues in terms of returning to work. For example, schools are closed for the most part through the rest of the academic year, and I think summer school in September is a bit of a question mark depending on where you are. So, the federal leave provides, certain types of paid leave due to childcare and childcare issues. Some of the local leaves require similar paid leave for childcare or senior care issues, but employers will need to understand what issues their workforce is grappling with and have plans in place to deal with those specific issues and make sure that they're complying with the types of leaves that they need to comply with. Another issue that may arise has to do with transportation in the sense that, number one, some employees may be hesitant to use public transportation. And a flip side is that some employees may be faced with a situation where, for example, some metro areas, subway ridership is significantly down. If service lines are cut, if service lines that were previously available simply are not available, you'll have to deal with, potentially changing work shifts, how to handle employees that have to get to the work site early or stay on late in order to have time to get to their public transportation. It's just one more logistical issue that will need to be hammered out. And if we can go to the next slide, another issue that will likely, particularly, for industries that are more office-facing than, say, construction-facing, will be requests to work remotely. So at the outset, employers may want to consider if their overall philosophy on remote work has changed. A lot of employees have been working remotely fairly successfully. They may want to continue to do so for a number of reasons. Employers that have had work from home requests in connection with accommodation requests in the past, prior to the pandemic, may need to revisit those requests and determine how to handle those types of issues. And as I previously did note, the types of requests that may come in if you've got a vulnerable population, if you've got somebody with a family member in a vulnerable population, there may be a significant number of people looking to work from home. And that, that can just carry with it a number of potential issues, such as reimbursement, what type of flexibility employers may want to offer for a certain period of time, potentially revising previous remote work policies, data security policies, maintaining confidential information. There are just a number of issues to consider in the remote work context. And if we can go on to the next slide, there are also a number of issues to consider in terms of physically determining if individual employees are safe to return to work before they actually come back to the workforce. So employers may want to consider screening processes that may entail self-certification or temperature taking, whether that's done on-site or off-site, has a number of issues that would need to be considered, potential wage and hour issues, et cetera. Employers may want to have a protocol in place for employees who, prior to coming back, had tested positive, maybe possibly obtaining a certification that they're able to return to work, although the EEOC and CDC has basically cautioned employers that certification requirements, is just in general, that certification requirements may need to be a bit more flexible. Just another high-level issue to consider in this process. And going back to, I know Camille mentioned EEOC guidance changing, and just today, and just to further stress the importance of how quickly these issues change and how much these issues are a moving target, the EEOC did adjust its guidance regarding COVID testing today in connection with its guidance on ADA standards. Effectively, the EEOC is stressing that the ADA standards must still be followed, but suggests that employees may be able to administer testing before entering the workplace. That also, it's certainly not a clear green light. It's just that it's permissible under certain circumstances. Employers need to wrangle with the possibility of false positives, et cetera. There are a number of issues that come into play there, but it's something that's potentially available in the toolkit in the right circumstances. And so with that, I will turn it over to Christina Medin. I know that there are a number of issues here, but we're able to provide this high-level bird's eye view. So with that, Christina, take it away.
Thanks, Elizabeth. So once you have selected employees to return to the workplace, whether that be the physical workplace or in a work from home setting, it's important to think through the logistics of reintegrating those employees into the workforce. The next slide, please. The employers will have different considerations depending on which employees it will be returning. So to the extent an employer may be returning employees who previously worked from home, employers want to think about the logistics for the return of any employer property and equipment that the employee may have been using, including taking an inventory of the property and complying with any sanitation protocols as it collects the property. For employers allowing employees to return to work but in a work from home setup, it will be important to confirm that non-exempt employees are accurately recording all time worked and are provided with legally required meal and rest breaks. Along those same lines, employers should keep in mind that employees may be entitled to reimbursements for necessary and reasonable business expenses incurred during the time that they are working from home. Employers could also consider obtaining a certification from employees, either contemporaneously as they're working from home or once they do return to the physical workplace. These certifications could certify that employees were provided with all legally required meal and rest breaks, that employees reported all hours worked, or that they were properly reimbursed for all reasonable and necessary business expenses during the time that they worked from home. So this could be a way to potentially mitigate some liability. Part of this reintegration plan should include developing a process for identifying and communicating with employees who may need additional accommodations upon a return to work. Employers need to make sure that they're engaging in an interactive process under the ADA with respect to these issues to the extent there's a medical condition involved. And along those lines, it's important to confirm the accuracy of any employee sick, vacation, and PTO banks. So for employees who may need additional leave time after they do return to work, we want to make sure that we're providing all leave that's protected, as well as providing leave in a consistent way. So it's a good idea to confirm that those banks are accurate. Finally, Elizabeth touched on this as well, but unionized employers must bargain over terms and conditions of employment unless a collective bargaining agreement gives an employer the right to proceed unilaterally. So when recalling workers or determining return to work procedures and requirements, employers should follow the terms of their collective bargaining agreements and bargain with the union over any issues that aren't covered by a CBA. Next slide, please. So for employers that may be returning employees but with different terms and conditions of employment, such as reductions in pay, reductions in hours, changes to work schedules, or changes to duties, there are a number of additional considerations that employers should be thinking about. So if a change in the salary level of an exempt employee falls below the minimum applicable threshold, the employee may no longer qualify for the exemption, and employers who do reduce salaries will want to think about whether they need to reclassify any employees as a result of this reduction in salary and develop protocols around that reclassification. Reclassification may also be necessary as a result of any change or modification in the duties of exempt employees. Many state laws require employers to provide advance written notice regarding changes to employee compensation, so employers should check these requirements before implementing reductions in pay as well. There are also potential issues with non-exempt employees working off the clock. So we've already talked a little bit about potential issues related to work from home, but to the extent employees are being required to perform symptoms checks at home, putting on PPE at home, waiting in line for temperature checks once getting to work, employers should be aware that this may be considered compensable time under certain state or federal wage hour laws, depending on the circumstances. Employers should also be mindful of potential meal and rest break claims around issues that may arise relating to social distancing protocols. So for instance, employees may be less inclined to have lunch in a break room given social distancing requirements and more inclined to eat at a desk or at a workstation, which creates risk of employees working or being interrupted during their break time. Employees leaving for or returning from a lunch break and having to social distance to get into an elevator or to take the stairs may also spend more time getting into the workplace before or after a meal or rest period. So it's important to think proactively to make sure that employees continue to receive their full meal and rest breaks as required by federal and state law and account for any additional potentially compensable time that could arise in light of these new social distancing protocols. Next slide, please. So before returning employees to the workplace, it's important for employers to ensure that they have the proper policies and employee communication plans in place. I'm going to talk in a little bit of detail about that. So we recommend approaching COVID-19 related policy development with an overall philosophy in mind. So in other words, do you intend to provide the minimum protections that are required by law, such as the minimum amount of legally protected paid sick leave? Or will the employer offer more generous policies that go above and beyond what's required under the law? Another consideration to think about is whether these will be temporary versus longer-term policies. If they are temporary, when will these policies sunset? Will these be standalone policies, or will they be part of a broader employee handbook? Regardless of overall philosophy, when returning employees to the workplace, there are a number of different policies that employers can consider implementing, which will, of course, vary based on specific circumstances around the return to work. One such policy is some form of an infectious disease control policy with generalized COVID-19 related guidance. This policy could include information about helping to prevent the spread of the virus in the workplace, the symptoms of the virus, protocols for employees who may be having symptoms, and other best practices for reducing the risk of exposure to the virus through good hygiene. Along those lines, updating social distancing guidelines and protocols is an important consideration, and this will be addressed in more detail in the next section. Employers can also consider developing communications around face covering masks, temperature checks, and other screenings to the extent those may be relevant. A few additional policies that are particularly relevant right now to consider or update are a travel policy, a remote work policy, new or updated paid sick leave policies based on recent COVID-19 related guidance, and other PTO policy considerations. Next slide, please. So once the employer has determined that it has the appropriate policies in place, it's important to think about how these policies will be communicated to employees. Employers can consider communicating new or updated policies before the employees even enter or physically return to the workplace. So if employers, for instance, have updated protocols to screen employees in a certain way before the employees enter the physical workplace, or other measures that may not have been in place previously, it might be prudent to communicate these new measures prior to the physical return to work. This could be by way of scheduling a remote or virtual meeting to educate or update employees, or simply disseminating the policies prior to the employee's return. It's especially important to communicate with those employees in human resources and management positions before returning so that these employees understand how to advise on and field questions about these policies prior to returning to work. In addition to or instead of the remote communication of new or updated policies, employers may consider having a half-day or full-day orientation on the first day that employees return to the workplace to introduce these policies and educate employees. And this will be particularly important for any new social distancing and other health and safety policies. Employers should also make sure that they're appropriately complying with any new posting requirements that Elizabeth touched on as well relating to the COVID-19 pandemic before returning employees to the workplace. There are a number of orders, for instance, in various California localities that do mandate posting requirements, so you certainly would want to be aware of those. Finally, employers should think about any renewed communication of policies that are already in place. So for instance, the EEOC recommends that employers remind employees about anti-harassment policies when reopening the workforce, so that would certainly be a consideration as well. And with that, I will pass to Anne Marie.
Thank you very much, Christina. So I'm going to discuss protocols to consider. And before I get started, I just want to make 3 points. The first is that it's not possible to eliminate all risk. It's really about optimizing the risk. Second is it's not a one-size-fits-all approach. The specific protocols that an employer is going to develop depend on many factors, including the industry and whether or not it includes any customer-facing employees, the type of workforce, including whether any portion of the workforce is unionized, the jurisdiction and applicable legal requirements, as well as the size of the workforce. And no one employer is going to want to implement all of the protocols I'm going to discuss today. Rather, these are key protocols that we believe employers should consider. So with that, I'll first talk about social distancing protocols. So each employer will need to develop and implement social distancing protocols. While the specific protocol will vary, as I said, all employers are going to want to consider whether and how to reconfigure their workspaces to comply with legal requirements. Many employers in recent years have moved to open workspaces, and so this particular consideration is now more important than ever. We also can learn from other countries, for example, who are ahead of us in this process. Japan, for example, has, there was an article recently about an employer who has installed plexiglass between cubicles in an open seating area. You also want to consider whether and how to repurpose conference rooms, lunch rooms, and other common areas. On this slide are additional considerations for reconfiguring your workspace. The bottom line is that each employer will need to think creatively and proactively about how to most effectively use its workspace in compliance with all applicable legal requirements. Next slide. Another type of social distancing protocol will involve considering reconfiguring schedules. And on this slide, we've highlighted a number of these considerations. Again, these are simply things for you to consider, not necessarily for you to develop and implement in your particular workplace. Also, with some of these considerations, you want to definitely keep in mind applicable legal requirements. For example, the second bullet talks about requiring employees to eat at their workstations. And certain jurisdictions, such as California, provide that employees must be allowed to leave their premises during their meal and rest breaks. Also, one point about the final bullet, I've spoken with a number of clients who've expressed concern about the large number of employees whom they predict will want to work from home, and how they will address and respond to all of those requests. And in this transition period, I would encourage employers to recognize that work from home arrangements may not be ideal for certain positions, but you should consider whether they're feasible for at least some positions for at least some of the time during the transition back to work, where social distancing and increased space will be of primary importance to prevent a future outbreak and a future need for a shutdown. So that's just something to keep in mind. Of course, I recognize that for some positions, especially in a manufacturing or factory setting, it's simply not possible to perform the job from home. But be flexible where you can, and try to limit the number of employees who are present at any one location at any one time. Next slide, please. On this next slide, we've included some other types of health and safety protocols and have outlined some best practices that employers should consider as they develop their own unique health and safety protocols. One point here is to really, it's key to identify at the outset a point person or two to keep track of all changes and legal developments. As we've discussed today, there have been developments this morning, and requirements are changing, guidance is changing, and so as you develop these protocols, even once you've implemented them, have point people keeping track of developments, remain flexible and nimble, and be prepared to make adjustments to your protocols as new guidance is developed. For example, this slide talks about considerations for health screening and testing, and as two of my partners have already mentioned, the EEOC issued guidance today confirming that in this COVID-19 pandemic, COVID-19 tests of current employees are job-related and consistent with business necessity, and thus permissible, but cautioned employers about being mindful to review guidance from the Food and Drug Administration, as well as the CDC and other public health authorities, including updates about what may or may not be considered reliable testing, and that is likely to change in this crisis. And you'll want to consider, before you decide on a particular test, the incidence of false positives or false negatives associated with a particular test. And again, don't be wedded to a particular test if it turns out that later on a more effective or less costly alternative becomes available. Next slide, please. So on the next couple of slides, we have included some cleaning considerations for you to think about. I'm not going to read through them all, but sort of an overarching point is that I know many of you lease space and, from a landlord and or have a property management company that you work with. And I think it's really important as you start thinking about these health and safety protocols to institute proactively regular and transparent communication with the landlord and or property management company, and collaborate to make sure that there isn't a duplication of efforts. You also want to make sure that your landlord or property management company is taking responsibility for cleaning of common areas, as well as social distancing, and also consider requesting notification in the event that there's a COVID-19 positive test in the building. Some other tenant has a positive test. And so you just want to collaborate and be transparent and ask for help from your landlord or property management company. Next slide, please. In addition to the cleaning considerations on the prior slide, here we've included some additional considerations. And in addition to working with your property or management company, you want to make sure that you, again, follow the CDC guidance. Also, work with employment counsel to understand OSHA requirements, state OSHA requirements, such as in California, we have Cal OSHA, as well as any guidance that has been issued by state or local officials. I would also consider in this area hiring a safety consultant, even for a one-time engagement, just in terms of advice for best practices for your particular location and or industry. I would also encourage you to talk with, as I'm sure many of you are already doing, with other employers in your particular industry and collaborate and get ideas from them. Next slide, please. So on this final slide in the protocol section, we've included some other safety considerations for you. In addition to the protocols, you are going to want to provide communication and training, both on the protocols that you've developed, as well as any changes to those protocols. It's important for employees to understand that, we are an uncharted territory. These protocols have been developed, but they very likely will be changing periodically, and so it's important that you keep them up to speed on any changes. With that, I will turn it over to my partner, Liz Watson.
Great. Thanks, Anne Marie. At this point, I want to announce the MCLE code for the presentation. The code is SS0912. Again, that's SS as in Seyfarth Shaw, 0912. Okay, next slide, please. So part of your return to work planning should include thinking about how the various protocols that you've developed are going to apply to non-employees in the workplace, such as visitors, customers, vendors, staffing agencies, delivery drivers, and contractors. So for example, it's important to coordinate with staffing agencies about safety measures. That's something that often falls through the cracks, because the client may assume that the staffing agency has safety covered and the staffing agency assumes the client has it covered. And it's just too important right now to risk that falling through the cracks. As you do that, you do need to be mindful of potential arguments that in doing so, it increases the potential joint employer and independent contractor misclassification risk. In addition, you want to be thinking about protocols for visitors. Are there ways that you can limit visitors in the workplace, such as conducting business remotely? What screening measures are you going to apply to visitors before they come on site? You want to think about protocols for customers, which may be different than other types of visitors. Next slide, please. It's also important to develop a set of protocols in the event of a COVID-19 case in the workplace. Unfortunately, I think there's a higher likelihood when businesses reopen, given the rate of community spread, that that's going to be something that many of you are going to need to deal with. It's important to designate a point person or a task force that's going to oversee the response. And that's important because you'll need to be ready to move quickly and decisively in the event that happens. It's going to be very important to follow the current guidance from the CDC, from OSHA, the EEOC, and state and local orders and laws. And as several people have noted, that guidance changes on a regular basis. So it's important that that point person stay current. Currently, if you have a confirmed COVID-19 case or you have an employee who presents with symptoms, you need to send that person home. If you have somebody who has potential exposure, the answer is more complicated. The current CDC guidance allows for critical infrastructure workers with potential exposure who do not have symptoms to stay in the workplace if certain safety measures are followed. But just because you can keep them in the workplace doesn't necessarily mean that it's a good idea. There are a lot of potential implications for that. For example, they may infect other employees. It may cause other employees to be fearful or be concerned that perhaps you're prioritizing profits over safety. In addition, some states, such as Illinois, have changed their workers' comp laws to create a rebuttable presumption that if employees in certain high-risk industries like healthcare contract COVID-19, there's a rebuttable presumption that they contracted it at work. So there may be implications for workers' comp. In addition, there's potential exposure to third parties for tort claims. We don't currently have any CDC guidance that would allow non-essential workers with potential exposure to remain in the workplace. The CDC made that exemption for critical infrastructure workers to avoid staffing shortages that could lead to disruption in essential services. And there certainly are arguments that that same rationale would not apply outside of critical infrastructure employees. So hopefully we will get guidance soon from the CDC and from states and other sources on that. Next slide, please. The point person, it will be very important to conduct a prompt investigation, and that will include two parts. The first part is contact tracing, so determining what employees may have come in contact with the infected employee. We don't yet have clear guidance on exactly how to do that, but we can piece together best practices from various CDC guidelines we do have. Generally, the look-back period appears to be 48 hours. You look at how close the contact was it within 6 feet? And you look at how prolonged the contact was. More than 10 minutes is a measure that has been put out by the CDC. You need to make determinations about who to send home, determinations about what communications to send out to potentially exposed employees and to other employees in the workplace, keeping in mind the need to comply with ADA and privacy laws, which generally say you need to avoid disclosing the name of the protected employee to the extent possible. The second part of that investigation is determining where the infected employee may have been in the workplace. You'll need to evaluate whether to shut down a specific area temporarily, or maybe it's the whole building, what level of cleaning will need to be required, and then whether you need to implement any additional safety measures when you do open back up. Next slide, please. In addition, you'll need to figure out whether if you have a COVID-19 case, is there an obligation to notify public health officials? That's going to vary by jurisdiction. Think about whether you need to notify your workers' comp carrier, evaluate whether it's a recordable incident on your OSHA logs. It's generally not required unless the nature of the workplace or specific facts make it likely that the person, the employee contracted COVID-19 at work. But you'll want to check the current guidance on that at the time and figure out whether you need to reach out to staffing agencies, vendors, and other third parties. Next slide. Should also anticipate the possibility of government enforcement. That could come from OSHA or from the police or sheriff, who are empowered to enforce the shelter-in-place laws. OSHA is not currently doing on-site inspections unless there's an emergency. They are getting a lot of complaints, and for the most part, they're following those up with letters for now. But at some point, that's going to change, and so you want to look at the procedures you would ordinarily have in the event of an unexpected visit from OSHA or the police, including training managers, designating a point person, self-audits to make sure you're in compliance, making sure you've got key documents ready to produce promptly, and evaluating when to seek legal advice. Next slide, please. And I think we covered that, so you could skip to the next slide. As numerous presenters have already said, it is critical to stay current on legal developments. It's hard to do. You're going to put together a set of protocols, and then the guidance is going to change the next day. So it's just really critical to stay current. Next slide. Contingency planning. You need to anticipate what's going to happen if business slows down and there's a need to, you've brought people back and maybe you're going to need to furlough them again. Anticipate what it's going to look like for your business if you get more requests for leave and remote work. What's going to happen if there's a second shutdown? There have been talks about another wave of COVID-19 in the fall. What will the second shutdown look? Are there any lessons learned from the first time around? Next slide. And look at your communication plans. Do you have current information, current contact information from your employees? And are you prepared to communicate quickly with your workforce? Do you have a PR and media strategy? Hopefully you won't need it, but it's challenging to do that in the moment if you do. And finally, the last point is we just are all going to have to be flexible as we're working through these return to work plans. These are unprecedented times. The guidance and the science and the politics are constantly changing. It's going to be a lot of trial and error. You try something, maybe it doesn't work. Maybe your employees are not reacting well to it, and you'll need to be nimble and constantly readjusting. The expectation shouldn't be business as normal. I think that we're all looking to a new normal, at least for the short term. Next slide. Okay, so I want to thank everyone for attending the webinar today. This was intended as a kickoff webinar on return to work issues. As Camille noted, we anticipate this being one of many more webinars to come. If you do have questions or suggestions on future webinars or materials that would be helpful to you, we would love to hear from you, and we'll do our best to respond and cover them in future webinars or alerts. The slides from today's presentation will be available on our COVID-19 resource page. Next slide, please. And this is some more information about resources that we have up on the resource page as well as upcoming webinars. So I want to thank everybody for attending.
This concludes today's webinar. We want to thank you for attending.